Hello, everyone, and welcome. My name is Sarah Nelson, Director of Capacity Building with the Massachusetts Charter Public School Association. I wanted to start out by saying that I know the start of this year has been just as hectic as last year, even though I know we all hoped it would be a much smoother transition. So I just wanted to thank you all for the work that you're doing every day and for taking the time out of your busy schedule to join us today for this webinar. A few logistics before we jump into our content. In a few moments, I will share the Zoom norms for the chat. So just a reminder, you should have seen the pop-up that this webinar is being recorded. If you don't want to be recorded for any reason, you can just turn your camera off. Please make sure you rename yourselves with your full first and last name and your school name as well, just so we can see who's on the call today. And please keep yourself muted while not sharing. It helps reduce any background noise. The chat box, which you should see at the bottom of your screen, please use it to ask questions. There will be time for question and answers at the end of the session today. Feel free to chat me any questions if you'd like to remain anonymous, and I will pass those along to our presenters as well. And if we run out of time for any reason and your question is not answered, I will follow up with Elka and Allison offline, and we'll make sure you get a response emailed to you as well. I will share the slides and recording of this webinar with you all as well for your reference or for other members of your team who couldn't make it today. And they'll also be posted on both our website and Elka's website as well. So before I introduce our presenters and turn the presentation over to them, I just want to highlight that Title IX was amended in 2020. And since many of our schools were operating remotely or in a hybrid model at that time, we know this may not have been a primary focus for you all in your work last year. So now being back in person, we wanted to make sure that you have all the up-to-date information about what K-12 schools need to know in regards to these new regulations. So with that, I'm going to turn it over to Elka and Allison, who will discuss the new Title IX regulations. Thank you guys all for joining us.
So greetings, everyone, and welcome to our webinar about the new Title IX regulations. We're here today to highlight some important elements of the new law that you as K-12 charter schools need to know. Before we get started, we'd like to share our background. My name is Elka Sachs, and with me is Allison Lennon. I'm a partner here at Krokidas and Bluestein and the head of our charter school practice. Allison is also a very valued member of our charter school group. Krokidas and Bluestein has represented charter schools since the first charter schools formed in Massachusetts in 1995. We have a full service charter school practice, including governance, state ethics, contracting, public procurement, real estate development and acquisition, finance, employment and labor law, special education, and student discipline. And we're honored to have represented the Massachusetts Charter Public School Association, today's host. As Sarah mentioned, if you have any questions at any point throughout the presentation, you can type them into the chat box on your screen, either publicly or directly to Sarah. While you can send questions at any time during the presentation, we're going to save our discussion for a Q&A period at the end. So about this presentation. Our goal today is to answer several important questions for you, from the very basic, what is Title IX, to the more nuanced, what procedural steps does Title IX require we take when we receive an allegation of sexual harassment? Although simple on its face, Title IX is a complicated law with a complicated history. We might not be able to answer every single question that you may have or address every single scenario that might arise. However, we do hope to equip you with the tools necessary to create compliant processes in your school and to know when to ask questions. So let's start with the basics. What is Title IX and why do we need to know about it? Title IX is a federal law that was enacted in 1972, prohibiting sex discrimination in educational institutions that accept federal financial assistance. When enacted, its primary goal was to increase women's access to educational programs in the traditional sense, making sure that women were admitted to schools on an equal basis as men and had equal access to activities like athletics. Title IX appears to have achieved, or is well on its way to achieving, its original goals, with the percentage of women earning a bachelor's degree actually surpassing men in about 1995, and the number of female students participating in high school sports strongly on the rise. When Title IX was first enacted, neither the predecessor to the Department of Education nor the federal courts had yet recognized sexual harassment as a form of sex discrimination, prohibited under federal law. However, that changed in 1997 when the Department of Education issued guidance clarifying that sexual harassment is a form of sex discrimination and is thus prohibited by Title IX. So the question then becomes, what exactly is sexual harassment and how must schools respond to it? Until 2020, these questions were answered sporadically via confusing guidance from the US Department of Education. In addition, the courts sometimes interjected and reached decisions that were not consistent with DOE guidance, at least at its face. In terms of the definition of sexual harassment, for the most part, the guidance over the years has been clear that it includes quid pro quo harassment, meaning when an employee conditions a student's participation in a program on the student's submission to unwelcome sexual advances, requests for sexual favors, or other conduct that is sexual in nature. But the real confusion over the years has related to when a hostile environment can constitute unlawful sexual harassment to which a school must respond. There was a Supreme Court case requiring that harassment be so severe, pervasive, and objectively offensive in order to be actionable. However, the Department of Education maintained that prohibited sexual harassment was harassment that was either severe, pervasive, or offensive. Although these seem to be a minor difference, the effect is significant. The court's definition of prohibited sexual harassment required conduct to meet all three conditions, which significantly narrowed the definition of prohibited conduct. The DOE, in contrast, took a much broader approach, taking the position that conduct that met any one of the conditions was unlawful. The DOE tried to rationalize its decision to take a different approach than the courts, explaining that its broad standard applied when enforcing Title IX against schools administratively, while the court standard is what applied in private lawsuits for money damages. This caused a lot of confusion. So, where are we now? The DOE responded to the confusion in its regulations in 2020 when it finally issued a set of regulations defining sexual harassment and outlining the precise steps schools must take in response to allegations of sexual harassment, which essentially codified the guidance that had been issued over the years. It adopted the court's narrow definition of sexual harassment from 1999. It defined sexual harassment to be conduct that meets all three conditions, is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the education program. In addition, it maintained that quid pro quo harassment is also unlawful and requires a response by the school as it would to sexual violence. This narrow definition of sexual harassment caused some pushback as commentators believed it to be too narrow. A single action under the new regulations, even if severe, may not satisfy the requirement that it be pervasive, and thus a school may not be obligated to respond under Title IX. That said, a school may respond to conduct that does not constitute Title IX sexual harassment under its own standards of conduct and disciplinary regime. So now that we've talked about what constitutes unlawful sexual harassment under Title IX, we want to jump into when and how a school must respond. There are two key terms that trigger when and how a school must respond to sexual harassment. First, A school is required to respond to sexual harassment when it has actual knowledge of sexual harassment. Second, a school is required to respond to sexual harassment promptly and in a way that is not deliberately indifferent. So those are the two key phrases, actual knowledge and not deliberately indifferent. Previously, the interpretation of these terms was left to the courts to decide and to DOE guidance. And determinations as to whether a school had actual knowledge of sexual harassment or responded appropriately varied significantly from case to case. Although the new 2020 regulations seem onerous, one benefit is that they clearly prescribe standards and processes that schools must follow in order to comply with Title IX and leave less room for interpretation. It is a fairly easy calculation to determine when a school has actual knowledge of conduct that might violate Title IX. Under the new regulations, if any employee of a K-12 school is aware of sexual harassment or receives notice of an allegation of sexual harassment, the school is deemed to have actual knowledge and must respond. It is slightly more complicated to evaluate whether a school has responded to sexual harassment in a manner that is deliberately indifferent. The new regulations provide that a school will be deemed to have responded in a deliberately indifferent manner only if its response was clearly unreasonable in light of the known circumstances. The regulations go on to prescribe specific procedural steps that a school must take to avoid acting with deliberate indifference. So we're going to walk through those steps, those actions step by step. We start with who's involved. What are the required roles? So we want to draw your attention to these terms because we're going to be using them when we discuss the step-by-step processes. The roles include a Title IX coordinator, an investigator, a hearing officer, a decision maker during the initial grievance process or an initial decision maker, a decision maker at the appeals level, and someone who can run an informal resolution process should the school decide to offer an informal resolution process. So we recognize this is a long list of roles, and schools are often limited in resources or may have an interest in limiting the number of individuals involved in sensitive cases, such as those involving sexual harassment. Certain of these roles may be taken on by the same individual, but others must be distinct. And we've tried to demonstrate it in a visual way. In particular, the same person may be the Title IX coordinator, the investigator, and the informal resolution facilitator, if there is one. In addition, the same person may serve as hearing officer and decision maker, both at the initial and appeals level, although the individuals at the initial level may not serve in those roles at the appeals level. Other than the Title IX coordinator, responsibilities of each of these roles is relatively self-explainable based on the title of the role, and we'll address each when we walk through the processes. However, we want to take some time to explain in a little more detail some important points about the Title IX coordinator. So each school needs to designate at least one individual to act as Title IX coordinator who is responsible for overseeing and coordinating compliance with Title IX. The school must notify its students and families, employees, and if applicable, any unions with bargaining units at the school of the contact information, including email address, of the Title IX coordinator. Likewise, this information must be prominently displayed on each school's website and in its student and employee handbooks. The information about the Title IX coordinator might best be placed in a Title IX compliant policy, which every school must adopt and provide notice of to its students and families, employees, and again, if there are any unions with bargaining units at the school. While on the topic of policies, we want to point out that schools should consider updating their regular student discipline policies to acknowledge that additional or different requirements might apply if the discipline involves a Title IX covered offense. So with that, the theoretical background, the terminology, I'm going to turn this over to Allison, who's going to go into depth about the new required processes.
Thanks, Elka, and hi, everyone. Welcome. Like Elka said, with that background about Title IX and the various roles and the need to adopt a Title IX policy, we'll now dive into the actual step-by-step process that a school has to follow once it has actual knowledge, and Elka described what that is, of sexual harassment or an allegation of sexual harassment. At its core, it's a 10-step process that we've listed here that I'll briefly flip through, but we're going to take each step in turn. The very first step is to evaluate whether it's appropriate to remove the alleged respondent, whether that be a student or a staff member, from school grounds on an emergency basis, pending your investigation. Both Title IX and Massachusetts student discipline laws have a process for emergency removal, but they actually seem to be in direct conflict with each other in a way that, as we see it right now, effectively precludes schools in Massachusetts from emergency removing students in Title IX cases. And it's complicated, but I'll try to briefly explain. Generally, under Massachusetts law, if you emergency remove a student, you must hold the disciplinary hearing within 2 days of emergency removing the student. However, as we'll discuss a little bit later, Title IX gives parties certain rights to documents and evidence before hearings are held, and those required timeframes for giving those parties those documents and evidence don't comport with the Massachusetts 2-day law. For example, and as we'll go over in a little bit more detail later, a Title IX investigation must last at least 10 days because the parties are entitled to review all of the evidence at least 10 days before the investigator finalizes his or her investigative report. And then after that, the hearing can't be scheduled for at least 10 days after the report is sent to the parties. So under Title IX law, this process is going to take at least 20 days, which means that you can't comply with the Massachusetts law to hold the emergency removal hearing within 2 days. So there's a conflict there, and we are actually trying to get some guidance on this question from DESE, but at this point we haven't gained any clarity. So in light of that conflict and in the absence of any guidance from DESE, at this point we're suggesting that schools reach out to legal counsel before they decide to impose an emergency removal on a student in a Title IX case. That said, I've kept some slides in the presentation here for you to review if you'd like, regarding the standards that must be met in order to emergency remove a student, both under federal and state law, and the processes that must be followed under both. Very, very briefly, Title IX limits the circumstances under which a school can emergency remove a student more narrowly than Massachusetts law does, effectively making it so that in a Title IX case, a school can only emergency remove a student if it determines that there's an immediate threat to the physical health or safety of any student or any individual. In non-Title IX cases, Massachusetts allows emergency removal on a broader basis. Further, again, very briefly, if a student is emergency removed in a Title IX case, that student's entitled to be heard immediately following the emergency removal on the very narrow issue of whether the emergency removal was appropriate, not necessarily whether he or she engaged in the sexual harassment that's alleged. Under Massachusetts law, students do not have this right to challenge the propriety of the emergency removal. I've also kept this slide here. I won't go through it in detail. This briefly gives a description of the timeline, trying to combine as best I could the timelines required by federal law and state law. So the next step in the process, once you've evaluated whether you need to emergency remove a student and putting aside the conflict, the next step is to determine whether Title IX actually applies to the allegation at hand. If Title IX applies, then the school has to follow the rest of the process, which we'll walk through together today. And you'll see that this process gives the students involved rights above and beyond the rights that they would typically have in a typical Massachusetts student discipline matter. If Title IX does not apply, the school can choose to proceed and address the behavior under its normal disciplinary procedures and code of conduct, as those procedures, whether they apply to students or employees, whatever the case may be. So to determine whether Title IX applies, let's look back at the original language, the actual language of the law. The law provides that no person in the United States should be subject to discrimination in any education program or activity. It also requires that the school be receiving federal financial assistance, but for the purposes of this presentation, we'll assume your schools do. And so, as is clear, there are three important elements there. One, it has to have occurred in the United States. Two, the alleged conduct must constitute discrimination, which we now know includes sexual harassment. And three, the alleged conduct must have occurred within the school's education program or activity. So to determine whether the conduct occurred in the United States is fairly straightforward. And we've already gone over what constitutes discrimination, sexual harassment. So at this point, we'll take a look at what it means to be within a school's education program or activity. Does it include conduct that occurs off school grounds? Does it include conduct that occurred via the internet or at a school-sponsored event? These are all good questions, and the new 2020 rules actually sought to clarify that. So the new rules consider conduct to be within the scope of Title IX if it occurred somewhere where the school had substantial control over both the person alleged to have engaged in the misconduct and the context in which the conduct allegedly occurred. Unfortunately, there's no bright line geographic test for this definition other than the fact that it doesn't cover conduct outside the United States. So you'll have to just address each case on a case-by-case basis. And note also that it does include electronic conduct, provided that the school had substantial control over both the respondent and that electronic context. So again, the answer to whether conduct occurs within the education program or activity of a school and is covered by Title IX may well fall into a gray area, and we can't really provide a one-size-fits-all or a black and white answer to that. So again, you just have to review each situation very carefully and make the determination on a case-by-case basis. Note that if conduct is clearly outside the scope of Title IX for any one of these reasons, it's not in the United States, it doesn't constitute discrimination, or it's not within the program or activity, then the school has to dismiss the complaint. It's a requirement to dismiss the complaint. And at that point, the school need not proceed with the rest of this Title IX grievance process, but it's free to proceed using its own disciplinary or grievance process that you might have. So once you've evaluated whether Title IX applies and you've determined that it does in fact apply, the next step is to contact the complainant to do a couple of things. First, you have to discuss supportive measures, and two, you'll have to explain the process of filing a formal complaint. Supportive measures have to be offered and made available to the complainant regardless of whether the student decides to take it to the next step and file a formal complaint. So what are supportive measures? Supportive measures are, they have to be non-disciplinary, they have to be non-punitive, and they have to be offered at no cost. A school is required to offer these and provide them to the complainant unless the school can document why it was not clearly unreasonable to not provide them. One example of when it might not be clearly unreasonable to not provide supportive measures rather, to the complainant is when a complainant refuses supportive measures. But you have to make sure you document that you offer them and the complainant refused them, and that was the reason that you determined it was not clearly unreasonable to not provide those services. So again, a school is required to offer and provide them to the complainant, and a school is permitted, but not required, to offer and provide them to respondents. Some examples of supportive measures include no contact orders between the parties and changes in their class schedules. And to the extent that a respondent is an employee of the school, an example of a supportive measure might be altering that employee's work schedule. Supportive measures have to be kept confidential to the extent that keeping them confidential wouldn't impair the school's ability to actually provide them. Overall, the Department of Education considers this an interactive process with the complainant, that starts when the complainant initially reaches out to the complainant to discuss the availability of supportive measures. So the Title IX coordinator should treat it like an interactive process that should explain what options exist to the complainant and hear the complainant out about what he or she wishes. So the next step is the formal complaint step. Whether an investigation is launched under Title IX and whether it really depends on whether a formal complaint is signed. Either the alleged victim or the parent or guardian can sign a Title IX complaint, a formal complaint, or the Title IX coordinator can sign it independently. This is noteworthy because it's fairly limited. The only people who can sign a formal complaint and trigger this process is the Title IX coordinator or the student or parent or guardian. So if a school employee observes what he or she believes to be sexual harassment occurring, that employee has to report it to the Title IX coordinator, but doesn't have the authority to actually sign a formal complaint, him or herself. In a case like that, the Title IX coordinator would then have to reach out to the student, to the alleged victim, to determine if the alleged victim would like to file a formal complaint. And if the alleged victim is either unreachable or doesn't want to file a formal complaint, then the Title IX coordinator must evaluate whether he or she should file one him or herself. In releasing the rules, the Department of Education really stressed the importance of respecting a complainant's wishes with respect to whether the complainant wants to file a formal complaint, which again then triggers this investigation and grievance process. But on the other hand, the DOE commented that schools must be mindful of the rule that they don't act with deliberate indifference. So it's a little bit tricky. So in other words, even when a complainant does not wish to proceed with a formal complaint, the school has to evaluate whether not pursuing a formal complaint, the Title IX coordinator rather, would constitute deliberate indifference, whether it would be clearly unreasonable in light of the circumstances. The rules aren't entirely clear on when respecting a complainant's wishes to not pursue an investigation would be clearly unreasonable, but the DOE does suggest that the school consider factors like the nature of the alleged misconduct, such as whether it included violence or weapons, or threats or serial predation. So if and when a formal complaint is filed by either the alleged victim or the Title IX coordinator, then the next step is for the school to provide all known parties, including both students and parents, with written notice. This is an example of where parties in a Title IX disciplinary process have rights above and beyond the rights they would have in a typical student discipline matter. That is, in a typical student discipline matter, the student complaining of the conduct doesn't necessarily have the right to be kept abreast of the situation. But here, Title IX requires that the school give this written notice to both the complainant and the respondent. The Title IX notice, this initial notice, must include a few different things. It has to include notice of the school's grievance process, including any informal resolution process that the school decides to offer. Our suggestion, because schools are required to have a Title IX compliant policy that includes this grievance process, we suggest instead of trying to summarize that policy in this initial notice, you simply provide a copy of that policy when you send this written notice. In addition, the notice has to include details about the allegations made in the complaint, sufficiently detailed so the respondent has enough time to consider it and to prepare a response before he or she is interviewed as a part of the investigation. At a minimum, these details have to include the identity or the identities of the alleged victim or victims, and the date and time of the alleged harassment, or dates and times if it was multiple occasions. Note that if during the course of your investigation, additional allegations come to light that were not disclosed in this initial notice, the school has to give a new separate notice with those new allegations, containing all of these elements all over again. This initial notice also must include a statement that the respondent is presumed not responsible for the alleged conduct, and that a determination about responsibility will not be made until the conclusion of the grievance process. Sort of an innocent until proven guilty kind of concept. The notice also has to inform the parties that both the respondent and the complainant, that they have the right to an advisor of their choice, which may be, but it's not required to be, an attorney. It also must inform the parties of their right to inspect and review all evidence that's obtained as part of the investigation, provided that the evidence is directly related to the allegations in the complaint. It also has to explain that this evidence will be sent to them at least 10 days before the investigator completes his or her investigative report. And finally, this initial notice must also inform the parties of any provision in the school's own policies that prohibit making false statements or submitting false information during the grievance process. Our suggestion is to include this prohibition in the Title IX policy so that there's no need to refer to 2 different policies when you send this initial notice, or 3 or 4, however many it would otherwise be. We would also, even if it's in that policy that you would send with this notice, we would suggest specifically highlighting it in the body of the notice itself. And Elka, I think I have mentioned this informal resolution process a couple of times, which we'll get into detail about later. But if a school it plans to offer an informal resolution process, it must describe that process in this notice. And again, if that's something that's included in your policy, that you can simply highlight that it exists in the policy and refer to the included policy. And again, we'll describe in more detail later what that informal resolution process looks like or can look like. And a last note about the notice. This is a special Title IX notice that's provided under Title IX. It's different and additional to other notices that are required under Massachusetts law. Under Massachusetts law, once an investigation is complete and a school is considering a suspension, a school must provide a different notice to the respondent with the date and the time of the hearing and other required information. This, again, this Title IX notice that we're talking about is separate from that Massachusetts notice. This one must be issued upon the receipt of a formal complaint rather than the one required under Massachusetts law, which is required upon the decision to pursue a suspension. Again, this is a good example of where students involved in a Title IX case have rights above and beyond what their rights would be in your typical student discipline matter. So after you provide this Title IX written notice, the next step is to launch an investigation into the allegations that are made in the formal complaint. In issuing the regulations, the DOE characterized the investigation as a, quote, search for relevant facts and evidence pertaining to the particular case. The DOE, though, recognized that schools are somewhat constrained in their ability to investigate allegations. So, for example, while the investigation has to be completed promptly, schools are somewhat limited because they don't have subpoena power. So there's some limitation on ability to collect evidence, and the requirement that it be conducted promptly imposes this sort of time constraint on it as well. So the DOE recognizes that these constraints exist. Throughout the investigation, both parties, both the complainant and the respondent, have the right to produce and submit evidence, either documentary evidence or evidence through witnesses, any desired witness they'd like. It could be both fact witnesses and expert witnesses. One important difference there are many, but in these Title IX rules and Massachusetts rules is that prior to these rules, it wasn't unusual for schools to either request or require witnesses and parties to keep the investigation confidential to protect the integrity of the investigation. But these new rules actually explicitly prohibit schools from prohibiting the parties from discussing the allegations under the investigation. So that was a mouthful, but there are two important limitations that we want to call out there. One, this limits confidentiality to the, quote, allegations under the investigation. This does not prohibit confidentiality about the discussion of information that does not consist of the allegations under investigation, like the evidence that's collected as part of the investigation or the actual investigative report itself. And second, this limitation on confidentiality, or when schools can require confidentiality, is only on the parties. Schools are prohibited from requiring that the parties keep this stuff confidential. Schools are not limited in imposing this confidentiality requirement on non-party witnesses. One note that's sort of outside the scope of this webinar, but I want to quickly make it, is to the extent that the investigation involves employees, schools have to be mindful of their obligations under the National Labor Relations Act, which prohibits employers from restricting employees' ability to engage in concerted activity. And concerted activity could include employees discussing investigations if it affects the terms and conditions of their employment. So you want to be careful to be mindful of your employment obligations as an employer when these investigations involve employees. In addition, throughout this whole investigation, the parties have the right, if they're required or expected to be at any interview or meeting or something like that, they have the right to have others present there. That could be their advisor, and most likely will be their advisor. Further, for each meeting or interview at which someone's presence is invited or expected, that person has to be provided written notice of the date, the time, the location, and the participants who will be there and the purpose of the event. And they have to be given that notice enough in advance so that they have sufficient time to prepare. And As we described earlier, when we were talking about what needed to be included in that initial written notice, both parties also have the right during this investigation to review any evidence that's obtained during the investigation that's directly related to the allegations in the complaint. This includes even evidence that the school doesn't intend to rely on when reaching a determination about responsibility. It also includes both inculpatory and exculpatory evidence that's good or bad for the respondent, regardless of the source of the evidence. The school has to send this evidence to the parties at least 10 days before the investigator completes his or her investigative report. So it has to be sent in advance, and then in addition, it also has to be available at the hearing itself. So at any time during an investigation or during a hearing, if it's determined that conduct is outside the scope of Title IX, then the school must dismiss the complaint. And I mentioned that briefly earlier. The school is permitted to dismiss the complaint on a few other grounds, and again, at any point during the investigation or hearing process. First, the school may dismiss the complaint if the complainant notifies the Title IX coordinator in writing that he or she would like to withdraw the formal complaint or withdraw any of the allegations within the formal complaint. They can kind of take a piecemeal approach. That said, if the complainant withdraws or asks to withdraw the complaint, the Title IX coordinator then must go back to the drawing board to evaluate whether it would be deliberately indifferent to not sign a formal complaint him or herself and to not proceed with the grievance process. Second, the school may dismiss the formal complaint or any of the allegations within it if the respondent is no longer enrolled or employed by the school. And third, the school may also dismiss the complaint if specific circumstances exist that prevent the school from gathering sufficient evidence to reach a determination about the complaint or the allegations in the complaint. I just want to point out, I didn't assign a specific step number to this dismissal step because, again, it can happen at any point during the investigation or hearing process. So I know I kind of just threw it in the middle of the process, but just keep in mind that at any point during the investigation or the hearing process, you can dismiss or must dismiss the complaint if one of these circumstances applies. One other note that even if a complaint is dismissed, the school must still offer the complainant supportive measures or be able to document why it was not clearly unreasonable to not provide the complainant supportive measures. I know there are lots of nots and double negatives there, so it can be tricky to keep track of. So back to our step-by-step. The next step is the investigative report. At the conclusion of the investigation and after those 10 days have passed since sending the parties the evidence, the investigator must create an investigative report. If the school intends to hold a hearing, which in Massachusetts the school is required to do if it's considering a suspension, the report must be sent to the parties at least 10 days prior to the hearing. The report must fairly summarize the relevant evidence obtained during the investigation and should not include a decision because the investigator is just investigating. There's a separate person who acts as the decision maker. So the investigative report should be sort of an objective evaluation of the evidence that was collected during the investigation. So again, the investigator has to send a copy of this report at least 10 days to the parties, at least 10 days before the hearing. And this is because each party has the right to submit a written response to the report. So that 10 days, which can be more, is meant to give the parties that time to review it and submit a response if they'd like. So the next step is the adjudication phase. A hearing, and this is a bit of a nuanced difference, but we'll walk through it. A hearing is not required under Title IX in elementary and secondary schools like it is in colleges and universities. So under Title IX, you folks aren't required to conduct hearings. That said, under Massachusetts student discipline law, it separately requires that a hearing be conducted if the school is considering a suspension. So because there are those variables, we'll walk through both possible scenarios. One, when a hearing is not required under state or federal law, and two, when a hearing is required under state law. So a hearing is not required under state law. That is, when a school is not requiring a suspension or considering a suspension, then Title IX, it simply requires that the school allow each party to pose written relevant questions to other parties and witnesses. The decision maker, there still has to be a decision maker. The decision maker has to decide the relevance of the questions before they're presented to the recipient, whoever's receiving those questions. The parties have to have at least 10 days to submit these questions before there's a decision reached. And both parties must be given copies of answers to the questions and the opportunity to ask some follow-up questions. So there's got to be a little bit of wiggle room for some back and forth there. So that, again, is when a hearing is not required under either federal or state law. And again, that's just when, under Massachusetts law, a school is not considering a suspension. A hearing is required, not under Title IX, but under Massachusetts student discipline law in K through 12 schools if the school is considering a suspension of a student. And that requirement stems solely from the Massachusetts student discipline laws. The hearing should be conducted pursuant to that Massachusetts student discipline law, which itself could be its own webinar. In fact, we have presented several webinars on the topic, so it's a bit outside the scope of today's webinar, but just be mindful that Massachusetts law, if you're considering a suspension, does require you to conduct a hearing. And what that suspension looks like depends on whether the school is considering a short or a long-term suspension. So again, a bit outside the scope of today's webinar, but we're happy to chat offline with you about if you have any questions about that separate Massachusetts student discipline law process. So following the hearing or the exchange of written questions, whatever the case may be, the decision maker then must issue a written determination on the matter. The determination has to be based on a specific standard of evidence, and there are two options. It can either be based on the preponderance of the evidence standard or the clear and convincing evidence standard. Schools are free to choose whatever standard they'd like to apply. That said, whatever one you choose, you have to apply consistently in both cases involving employees and students. So one important note is that if you have employees who are unionized, you need to check their collective bargaining agreements to determine whether those CBAs require the use of one of these standards. And if they do, you have to apply that standard to all cases, all employees, whether unionized or not, and students. So review your CBAs carefully. So again, the written decision has to use one of these standards of evidence, and then it also must contain several very specific elements. And those elements, you really have to think about. It has to satisfy the elements of Title IX and also Massachusetts student discipline law. Under Title IX, the written determination must identify all of the allegations potentially constituting sexual harassment, and also a description of all of the procedural steps that were taken throughout the investigation. This includes sort of summaries of notices that went to the parties, when and what interviews occurred, when and what site visits occurred, and any other methods that were used to gather evidence, and also the hearings that were held. It also must include findings of fact supporting the determination and conclusions as to if and how the school's code of conduct applies to the facts. It must include a statement of and a rationale for every allegation. And it also has to include a determination about responsibility and any disciplinary sanctions that the school decides to impose on the respondent. It also has to describe whether remedies will be provided by the recipient to the complainant in order to restore or preserve the complainant's equal access to the education program or activity. So those are sort of continued supportive measures. And I didn't note this before, but that was a shift in terminology from the prior law. Previously, supportive measures were called interim measures. Now they're supportive measures to reflect that they're not just measures provided in the interim investigation phase. These supportive measures should be offered during and after the investigation and the decision. And so this final decision has to describe if and what sort of remedies are going to be offered to the complainant. Lastly, this notice, at least under Title IX, has to describe the appeal process under Title IX, and we'll walk through what that appeal process looks like. And as you can see on your screen, Massachusetts student discipline laws prescribe additional elements that must be included in the final determination if a suspension is imposed. For the most part, they're covered by the Title IX requirements, but I decided to list them separately here for you so you can see what the individual requirements are. And this written decision must be provided to both parties simultaneously. So I think the best way to do it simultaneously is by email. So the final step in the process is the appeal process. And it's interesting under Title IX that both parties have the right to appeal. So if the decision maker determined that the respondent was not responsible for the misconduct and the alleged victim disagrees with that, the alleged victim may appeal. And that's very different than the student discipline laws in Massachusetts, where only respondents have the right to challenge their own suspension. That said, there are very limited reasons under Title IX that permit a party to appeal. Title IX requires that the schools permit appeals based on 3 different grounds. If a party believes that there was a procedural irregularity that affected the outcome, or if there's new evidence that was not available before that could affect the outcome, or if the party believes that the Title IX coordinator, investigator, or decision maker had a conflict of interest or was biased in the process. So Title IX requires that schools permit appeals on those grounds. It also allows schools to offer additional grounds to appeal. So if you would like, you can, as long as you allow those grounds, if you allow both parties to appeal on those additional grounds. And then in addition, if a long-term suspension is imposed against the respondent, then the respondent under Massachusetts student discipline law has the right to appeal the suspension, regardless of whether one of these Title IX bases are met. So I know we flipped the term informal resolution around a few times, so I'm gonna turn it over to Elka to give us a little bit of background of what that means and what it could look like. Elka, you're on mute.
Thank you, Allison. So I'm just going to take a minute to talk about the informal resolution process. So schools are not required to offer an informal resolution process, but there are guidelines as to how it must be offered if it exists. At any point in the process that Allison described, before a determination is made, the school may offer an informal resolution process to the parties. The informal resolution process must be voluntary, meaning both parties need to consent to it. It can only be offered after the formal complaint is filed, and a school is not permitted to offer informal resolution processes in cases where the allegation of sexual harassment is made by a student against an employee. It's only available in peer-to-peer sexual harassment circumstances. There are no specific guidelines as to what an informal resolution process must look like. Clearly mediation is a version of an informal resolution process. It's been suggested that the use of restorative justice techniques may also be a form of informal resolution process. Informal resolution processes can only be offered if written notice has been provided to the parties that includes the allegations, the requirements of the informal resolution process, including the circumstances under which the parties would be prohibited from resuming the formal complaint process, the consequences that could result from participating in the informal resolution process, including the records that will be maintained as part of the process or which may be shared among the parties. So we suggest that if you're going to offer an informal resolution process, that you do so in the initial written notice that we had described in step 5, or that Allison had described. If informal resolution process is offered and both parties consent, just be aware that schools are still obligated under the Massachusetts student discipline laws to hold a hearing if there is a possibility that suspension might be imposed on the student. So that is a limit to how the informal resolution process might be utilized. And Allison, I'm going to turn it back to you to talk about training.
Thanks, Elka. I'm going to try to go a little bit quicker. I know we're coming up against some time here, and I want to be able to leave time for some questions. As we've talked about, this process is very, very detailed, and it's very different than your typical Massachusetts student discipline process. But it's very important that schools comply with it. So training is incredibly important, and it's important both because it's very complicated and important, but also because Title IX requires certain training. Title IX requires that Title IX coordinators, investigators, decision makers, and informal resolution facilitators be trained on specific topics like the definition of sexual harassment and the scope of the school's education program or activity. They also have to be trained about how to conduct an investigation and how to conduct the grievance process, including the appeals, the hearing and the appeals processes. The training has to include training about how to apply the definition of consent or the lack thereof consistently. And notably, the DOE doesn't prescribe a definition for consent. It leaves it up to schools to do that, so long as the schools create a definition that's applied consistently. These folks must also be trained about the informal resolution process, which Elka just discussed, and they must be trained about how to perform their duties impartially, including how to avoid prejudging the facts at issue and how to avoid conflicts of interest and bias. In addition, decision makers must be trained about technology that might be used at live hearings and on issues of relevance and evidence, including when evidence about the complainant's sexual history is not relevant. Note that Title IX considers questions and evidence about a complainant's sexual predisposition or prior sexual behavior to generally be irrelevant unless the questions or evidence are offered to prove that someone other than the respondent committed the alleged conduct, or if the question or evidence concern specific incidents of the complainant's prior sexual behavior with respect to the specific respondent and are offered to prove consent. Lastly, the Title IX regulations require that investigators be trained about how to create an investigative report that fairly summarizes relevant evidence, meaning that they must also be trained on issues of relevance. Title IX, although it requires those are required trainings, it does give schools some latitude to train staff more broadly on other topics. One particular training that we highly suggest is training of all staff on the importance of reporting allegations and how to report them and the Title IX policy. And this is important because, as Elka explained early on in the presentation, a school is required to respond when any employee has notice of an allegation of sexual harassment. So they need to know to report it up so that you can start this whole process. Other optional trainings, in the interest of time, I'm going to just leave them up on the screen for you to see, but there's a list of other optional trainings on the screen. Title IX also imposes a 7-year record keeping requirement, and it requires schools to keep their Title IX case files for 7 years. This has to include essentially anything that was created as part of the Title IX investigation. Schools are also required to retain their training materials for 7 years and also post their training materials on their website. One thing to consider that I don't think is always obvious is because you're required to maintain training materials for 7 years, every time you update your training materials, you have to keep those historic versions, those outdated drafts for those 7 years as well. And then very, very briefly, before we turn to questions, we want to point out that Title IX often interacts with other laws in interesting ways, and schools must be mindful of their obligations under each law. The substance and processes required by these other laws are outside the scope of this webinar, but we just want to make sure schools consider them when dealing with all matters of student affairs, including Title IX investigations and allegations. For example, as we've discussed throughout this presentation, the Massachusetts student discipline laws impose their own sets of rules and standards that you have to consider. Schools also have to consider their obligations under the Massachusetts bullying law, which requires a separate process. And schools also have to consider and make sure that their processes are compliant with the laws governing students with disabilities, including IDEA and Section 504. Again, these all could be their own webinars, so they're kind of outside the scope of today's webinar, but we are happy to chat offline with anybody if you have questions about these other laws. So with that said, with 5 minutes to spare, we will take some questions. I don't think any questions. Oh, we just got our first question. I'll let Elka take the lead. You're on mute, Elka.
Okay, so our question is, so informal resolution is not an option where a student may have sexually harassed a staff member. Okay, so that's a little bit of the reverse of what I had suggested. But I think the answer is yes, that it's not, I mean, it's not available. So this is a situation where the employee would be trying to bring a Title IX complaint against the student.
I can jump in.
Yeah.
I don't know that it would be covered by Title IX. Title IX prohibits sex discrimination. If the sex discrimination prevents the person's equal access in the education program or activity.
Right.
A student is participating in your education program or activity. So it's meant to protect students' participation. Employees, they're offering that education program or activity. They're not participating in it. So I actually don't think Title IX applies when a staff member is the alleged victim.
Right. I mean, you could have an odd circumstance where there's a hostile environment, but it would have to be really, really severe, I think, where students themselves felt threatened by the student's action against the employee. But you're right. It's not what was intended here.
That's the only question then. You made it up.
Okay.
You made it easy.
So I'm going to raise a question for you, Allison. What do you think the most significant change in the new Title IX regulations is?
There's a lot of them. I think it's the real narrow definition of sexual harassment. I mean, it's a change in that there was just conflicting guidance before these regulations came out. And these new rules require that the conduct be severe, pervasive, and offensive. I mean, that's very limiting. Whereas previously schools would have responded to something that was either severe, pervasive, or offensive in a Title IX compliant fashion. So I think that's really significant. I also think these new Title IX rules, like you explained, Elka, they created all of these new roles in the school and these hats that employees have to wear, which is, I think, a big administrative and operational shift for schools that they have to be careful of. So that's not as heavy as a lift or as impactful maybe as the narrowing of the definition of sexual harassment, but I do think it makes a real difference in operations at schools.
But up front, the school only has to identify the Title IX coordinator. Is that right?
That's right.
So the other roles could theoretically be decided on a case-by-case basis.
True, although if you're going to, these people have to be trained. So if a case comes up, you can't just be like, you're the investigator, unless that person's already been trained in all of those specific training topics that investigators have to be trained on. So you do have to identify who you're going to train to act in these roles. But you could have 5 investigators and assign one to certain cases on a case-by-case basis.
All right, so with that, I think we're going to close our session and thank everybody for attending. Feel free to follow up with any questions. As Allison has made clear, this is a complicated process and it's a layer on top of existing law that applies, the Massachusetts student discipline regulations being noteworthy, but also the bullying statute, as you mentioned, especially with regard to cyberbullying. I think you could see a lot of overlap there. And also, of course, rules that apply to children with special needs. So thank you again, and we look forward to hearing from you.
Thanks, everyone.
Thank you. Have a good day.